You're tuned in to Agriculture Today, and we start our Wednesday show talking about things related to agricultural law with Key State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Good to be with you, Shelby.
Roger, talking about a handful of different cases today, and the first one starting off a case when it comes to motorists and a liability with tree limbs.
Yeah, this is an issue that comes up periodically, and the question is, am I responsible as a farmer for things on my farm that can create problems to people that are passing by, say, on a public roadway adjacent to my farm? And I get into this issue with people that will ask me questions concerning crops that are planted close to the roadway. What's my responsibility there? If I'm planting, for example, a tall crop such as corn, do I need to back it off a bit? How close to a corner can I plant? Is there any rule with respect to that? And then what about vegetation? Is it my responsibility to make sure that a tree doesn't fall on the road, that there aren't limbs that could come down and cause a traffic hazard, those types of things. And the general rule is no, you don't have a responsibility for things that could happen off premises. It doesn't mean you shouldn't exercise common sense, but the general rule is no, if you've got a tree, for example, that falls and it falls on a road and injures somebody, you're not responsible for that because that's something that occurred off premises and you're not responsible for that even though the tree was on your premises. There are exceptions, of course, but the general rule is no, and the same thing applies with respect to crops and vegetation.
And this was a recent case in Texas of why it kind of got brought back up again this time?
Yeah, that's right. It came up in an East Texas case. There was a windstorm that uprooted a large oak tree on a farm, and it fell across a road. Well, the driver hit the tree and sued for her injuries, and she claimed that the farmer failed to inspect the premises of the farm to ensure that objects on the farm were not a hazardous to roadway motorists. And the farmer pointed out, said, look, there was no evidence. I didn't have any evidence that the tree was rotten or there was a problem with it. And the farmer actually produced an affidavit from an arborist that said that the tree was healthy, had no outward signs of decay, and would have required a tremendous wind to blow it down, which indeed is what happened. But again, this ended up in court.
What happened once it did get to court?
Well, the court ruled for the farmer, and again, it's the general rule. There is no duty to parties that are injured off premises because the landowner is not in possession and control of those areas. But while the court said that a landowner doesn't have a duty to make an adjoining road safe or to warn travelers of potential danger, the court indicated that there can be exceptions to that, but none of those exceptions applied in the case. And again, I go back to what I said earlier, and the court pointed this out. This was a farm that was in a rural area. There was no evidence that the farmer knew or should have known of the danger posed by the tree, and it wasn't evident by simply looking at the tree. And in addition, motorists have a duty to drive according to the conditions, and that includes being able to spot a large oak tree that's blocking both lanes of a road in time to avoid hitting it.
And Roger, also wanted to mention something else that's kind of taking place in agriculture quite a bit, solar panels and how zoning plays a big role in that.
That's right. It's not dissimilar to where we were at with respect to wind energy 30 years ago when a lot of county and local municipalities didn't have rules in place that would put any type of restrictions in the way of the development of those. And so that's where we're at largely with solar panels. Many of the local zoning rules leave the door wide open to the potential for farmland to be converted into usage for solar panels, and there's no extra step that's required to go from ag to solar. And this is a commercial use, and normally when you change a use of property from ag to non-ag, there's a zoning step that you have to go through. And some of these solar panels are getting put on prime farmland. That's another concern also. But on the zoning issue, one study has forecast that 83% of solar energy development is going to be on farmland and ranch land unless current governmental policies are changed, and about half of that amount is projected to be on the nation's most productive soil. So, in my view, local zoning and planning commissions need to be at the forefront of this issue because rezoning or permitting should be necessary to convert farmland to solar fields. That's an industrial use, and traditionally, as I indicated, a change in classification involves a public process, and so the public should be involved in this.
Roger, another important case really taking place in agriculture when it comes to things that could impact farmers. Supreme Court has recently made a decision on buy-sell agreements.
Yeah, actually, we've had several very significant U.S. Supreme Court opinions that bear on agriculture in one way or another. And what they said with respect to a buy-sell agreement, and by the way, I think a buy-sell agreement is perhaps just as important as a properly drafted will or trust, particularly if you're planning on keeping that farm in the family throughout subsequent generations. You need a good buy-sell agreement, particularly if you have both on-farm and off-farm heirs. What we had in this situation was a small business in the St. Louis area. It's non-farm, but the same principle applies. And it was two brothers that operated the business, and they had a buy-sell agreement where the corporation would redeem the stock of a deceased shareholder. There would be a redemption. And the insurance policy that was funding the buy-sell agreement, those proceeds would go to the corporation to redeem the stock of the deceased shareholder. One of the shareholders died, the one that owned most of the stock, and so the corporation gets over $3 million worth of insurance proceeds for the other brother to buy out his deceased brother. Well, the question was, does the policy proceeds increase, or do the policy proceeds increase the stock base and then cause a tax problem in the deceased brother's estate? And the court said, yes, it did in this situation. Now, they said it wouldn't necessarily be the case in every redemption-style buy-sell agreement, but the brothers didn't pay attention to what was required under the buy-sell agreement during life, and so the lower courts felt that they didn't have to pay attention to it after death, and the Supreme Court said that was right. So there are a lot of details that I'm kind of glossing over on that, but it does point out to us the peril, perhaps, in using a redemption-style buy-sell agreement and the need to use what we call a cross-purchase agreement, maybe with also an insurance LLC, and that's a really complex topic. But for our purposes today, I think we just need to raise the attention that maybe that plain vanilla redemption-style buy-sell agreement is not the way to go anymore.
Another topic wanting to bring to the attention of people, especially our farmers and ranchers, the repeal of the Chevron Doctrine, something that's been around for 40 years.
This is huge. The Chevron Doctrine comes from a U.S. Supreme Court case in 1984, and under that doctrine, courts are to defer to an administrative agency's interpretations of a statute where the intent of the Congress was ambiguous and where the interpretation is reasonable or permissible. So that set a pretty low hurdle for an agency to clear. If the agency's interpretation of a statute wasn't arbitrary or capricious or manifestly contrary to the statute, then the agency's interpretation would be upheld. Well, farmers and ranchers get into a lot of agency snags. USDA has various branches. NRCS, for example, is one that farmers deal with constantly, and there are a lot of regulations out there. If you're in the Federal Farm Program, there is a huge manual that the FSA uses that has all their rules and regs in it, and it's their interpretation of what the existing law is. And under the Chevron Doctrine, if they were reasonable in their interpretation, they win. And that has created issues for farmers and ranchers for a long time. Now the court said, no, that's not right. And one of the things that the court said was these agencies don't have any special competence on construing statutes. The courts do. And so this kicks it back to the courts to determine ambiguous statutes. And I think it'll have an impact on how the agencies write their rules and the administrative process. And I think it'll have an impact there. But we'll see what happens because it's going to be up to the courts now to construe congressional language, not the administrative agencies.
What could this mean for farmers and ranchers?
Well, I think it has a couple of impacts. I think it'll have an impact on the administrative agency review process, but it'll also have an impact on how the agencies write their rules. They're going to have to pay much closer attention to the statute, the legislative history, and what the intent of the Congress was, and stay very close to that, or they will get overturned. And again, on the backside, I think if a farmer gets into a snag with an administrative agency and you go through the administrative agency review process, I think it'll have an impact on that review process too. But the way the rules get written is going to be the primary impact of the court's decision.
And Roger, rounding out today's conversation, making a mention of some things that have been happening when it comes to water compacts.
Yeah, this is another U.S. Supreme Court opinion that came down in June, and this involves specifically the Rio Grande Compact that was signed back in 1938 between Colorado, New Mexico, and Texas. And it had to do with how the states would apportion water out of the Rio Grande Basin. And this has ended up in litigation. About a decade ago, Texas sued New Mexico for allowing the water in the river to be channeled away for its use, which deprived Texas of its equal share of the water under the compact. And, of course, you got the federal government that's involved in this, too, because they have to fulfill treaty obligations to Mexico with water in the Rio Grande. So the question was, after the 2014 litigation, Texas and New Mexico tried to do their own agreement, say, we're going to settle this thing, we're going to come into our own agreement, but they didn't include the federal government. Federal government has to be involved when they have an interest such as this. The Constitution says the states can compact, but the Congress must approve, and that's what the Supreme Court said. The federal government has a role and has a say in this compact.
Roger, I appreciate you taking the time to join us today.
Thank you, Shelby.
That was K-State and Washburn law professor Roger McEowen. I will link articles in today's show notes on agtoday.net if you'd like to read more about these topics.